Here's your host, Giuseppe Grammatico, the franchise guide.
Can you talk a little bit about that?
Sure, absolutely. Now, most franchisors are going to take the stance that there's nothing negotiable in the documents. And I understand that because that's how I dealt with things. When I was general counsel of CycleBar, I wouldn't change anything, but it provided an opportunity for me to explain why we've got it in there. And so if there's an area that I think you could potentially ask the franchisor to make a change, I say ask it. And so the ask is twofold, or the importance, it's important for two reasons. For one, if they say yes, great. They will write up the addendum or the amendment and they'll send it to you. And then you just send it to me and I'll review it and say, it says exactly what it's supposed to. And there you go. But the other reason why you should ask it is so it does provide that opportunity for a franchisor to explain why they've got it in there. A liquidated damages clause. When you take a look at that, candidates say, oh my gosh, there's a liquidated damages clause in here. Well, yeah, there's a reason why there's one in there. Have the franchisor explain it. If they can't explain it, I don't know, maybe it shouldn't be in there.
Agreed. Yeah, that makes a lot of sense. And I mean, the document's written in simple enough terms, but for someone to get through the document, not saying they understand all the law, but it's written, I forget at what grade level, but it's simple enough that everyone should be able at least to read through it, maybe not understand it completely, but it's not an overly complicated deed, if I understood correctly.
Correct. It's just dense. When it's a lot of pages.
Yeah.
I tell a lot of my clients, look, I'm like the Cliff Notes version, the yellow and black documents you used to use in middle school and high school. I will go through the documents and raise issues that you aren't aware of because you may be focused in on an area that you think it's worrisome to you, but in reality, it really shouldn't be where you're focusing your time. You should be worried about another area. So I explain, hey, look, maybe you should be looking at this when you've spent most of your time looking at that.
Okay, that makes sense. I always tell people, will say, well, the franchise agreement seems to be written in the favor of the franchisor. And I take a step back and say, you are right. It's written in the favor of the franchisor, but really it's written in the favor of the brand itself, because at the end of the day, they want all franchisees presenting themselves the same way, the same brand, the same service, the colors, the fonts, to all the details, so that they're not making special arrangements. Well, we're going to treat you this way, and then all of a sudden treat someone else a different way, or give them all these exceptions. And ultimately, they want to keep it universal. They want to keep everything fair, everything the same. But on occasion, maybe there is some wiggle room. I don't know if you can even talk about that, but I'd say, what would be an example of maybe a negotiation or a change in an agreement, if any?
Well, first, you brought up a good point. Most of my clients, when they're looking at the franchise disclosure document, the franchise agreement, they see, oh my gosh, the franchisor can do a lot. There's a lot of franchisor may do this, may do that. Well, first they've got to understand that this document is good for the next 10 years, most likely. Most franchisors have 10-year terms. They're occasionally 5-year terms and sometimes even 7, but 10 is the most common. So this document has to be able to survive all the changes in economic conditions with competitors and with building a system. Maybe they've got 10 franchises now, but they'll have 200 in 2 years. And so this document's got to be able to deal with all that change. And so you want to have good lawyers drafting these documents that are going to protect the franchisor. And then it's also going to protect you, the franchisee. And so there are a lot of ways that you can see actual fairness in the documents. One of the areas is a prevailing party provision. Anytime I see a prevailing party provision, that means basically that the franchisors agreed, whoever wins in a lawsuit, if we've got a dispute and it comes to blows and we either have to go to arbitration or litigation, if there's a prevailing party provision, it says whoever wins gets their legal fees paid for by the losing party. And when I see that, I think, wow, that's really good, because if the worst case scenario does occur, if you're actually right and you proceed, that you will have your legal fees paid for. So you're not out anything. And it causes both parties really to come to the negotiations table before they spend a lot of money and time going down the path of litigation. So that's one area where I see actually more fairness brought into this. Now, you mentioned originally, do franchisors, are they willing to make changes to documents? Yeah, occasionally they are. And I can't predict when they will do that because it's dependent upon a variety of factors. They may say, well, we really love this franchisee, so we'll be willing to bend the rules a little bit for them and provide them maybe a right of first refusal on an adjacent territory.
Right.
Or maybe give them the opportunity to expand for a cheaper price, maybe give them a discount. And again, if they are willing to do that, they will write it up and then send it to you, the candidate, and then you can send it to me and I'll review it. But most of the time, franchisors really don't change a whole lot. My review isn't about going through and redlining the documents and sending you 50 pages of changes that we'd want to make. The franchisor would just take a look at that and say, well, no, we don't make any changes. Your lawyer just spent $15,000 or you just $15,000 in legal fees for no reason. It's really about understanding all of your rights and responsibilities and realizing that you are not powerless in this relationship, that you do have rights. And if the franchisor does mess up, you can do this or that. It's really about understanding what you're buying into because it's
Right.
a 10-year contract.
Given the length of time, it's very important to review it. Even if you're working with someone, review the document, go through it a couple times, cover to cover, make sure you understand it. Mark your own notes there. I think that's something I recommend to everyone. And the biggest piece of advice here is get everything in writing. So if you are discussing something and someone says, yeah, we could do that, or we can arrange that. Maybe it's, we had someone that needed an extension for personal reasons. They couldn't meet the 6 months and it was a pretty good reason and we'll extend it. I go, just get everything in writing. Let's just play it safe. It's not that people forget, maybe employees leave within the organization. So it's always a safe bet.
Understanding the FDD is vital, but what happens when you sell your franchise midterm? Do buyers inherit your agreement? And how are financial performance claims item 19 presented? Let's clarify.
Thanks for tuning in. If you want to learn how to make the transition from corporate to owning your franchise, join Giuseppe on the next episode. You can also follow on all social media platforms and achieve financial and time freedom today.